the more you talk over me, I will continue to mute you.
Ma'am,
I'm telling you that the number that shows up on the system is not an updated number, but you refuse to listen to me. So Mr. Tullis, basically, she's going to have to start paying you $345 and additional $69 starting April 1st.
Okay. You said 30. You said she'll pay me what now? Let me write this down.
$345 plus an additional $69 a month.
Okay.
So
what if that's not met?
Starting April 1st.
What if that's not met? Because it's kind of been just like she'll start paying, I guess, when the court date is coming up, and then it just goes away. And my son is still, I'm fully with me, and I'm just trying to figure out, like, I guess I've been on the other side of things before when I haven't had a job and, haven't had, been on child support. And I've just seen the ball start rolling a little bit faster with license being suspended, the possibility of incarceration, things of that nature. When will this?
What we can do for Mr. Tullis?
Yes. Okay, Mr. Tullis, this is where we are right now. This is an adjudication of arrears, which means we needed to get that dollar amount solidified so that it's now a debt owed against her. It's never going to go away. So we have that in place. We're also going to monitor her payments. If she's not making her payments after 60 days, then automatic suspension for admin things such as driver's license, passports, tags, that start. At the end of 90 days, the case is normally referred over to my department, which is where we are right now, for review for a contempt action because she's eligible for contempting now. If the court finds that she's in contempt and she's not paying and she has the ability to pay, then what will happen is she will go ahead, the court will set a purge. If she doesn't pay the purge, then there's the possibility of incarceration. I need to caution everybody listening in that this is civil. This is not criminal. So Judge Manning doesn't have the legal authority to just lock someone up until they paid the full balance of a purge, because that's what we call debtor's prison, and you don't have that anymore here in Georgia. If she is not working because of barriers to like education, criminal records, or things like that, there are services that we can help give her that will get her on track so that your son is getting, or you're getting assistance for your son as needed. And because we've adjudicated this, I believe we may have Ms. Freeman reach out. I need to think about that and see if she's eligible for the PAC program or if she's not employed or something. But those things are happening right now. So nothing's different depending on whether you're male or female, mom or dad. Whoever is supposed to be paying that money to child support, the same steps happen that happened before.
Okay.
As far as we're concerned, it's only about your son at this point. We play no favorites here.
Right, exactly.
Or at least I don't.
Yeah, I surely do appreciate it breaking that down for me. I just want to know how the process went. And that's kind of clear. So like we're looking at now, April, you said, this 345 plus the additional 69 to start.
Yes. And if she's not paying child support like she's supposed to consistently now, then they'll start reaching out to her to ask if she needs services. And if she doesn't respond, then the regular, we have to do the admin part first, which is suspend licenses and all of that. And then it can come to contempt. And unfortunately, we may have to ask you to come back to say that you haven't received anything later on down the line. But that's how the process will go from here on out.
Let me add this that I know. She hasn't had license in years due to suspension of her license for drunk driving and things like that.
Oh, we don't need this because
I'm sorry.
Okay.
I'm sorry.
That's okay.
I'm sorry.
We're gonna use this. Yeah, that's okay. That's okay. I understand.
But I guess my question is that a step that gets skipped if that's already has happened?
No, unfortunately not, because the way the law is set up. But we've had this case. You filed. We filed this case a while ago, so she may be eligible to be looked at for contempt more quickly if she's not been making payments consistently. I don't have her last on my note. Agent Ms. Freeman, can you see when her last payment was?
Her last payment was made on January 31st in the amount of $85.80.
Okay, that's relatively low. So, but a payment was made, and so that's going to trigger the clock to start over. But what I'm going to ask our PAC coordinator to do is reach out and see what's going on. If you can for me.
The court begins by addressing the issue of communication and payments, making it clear that speaking over the judge will not be allowed, and the participant will be muted if this continues. The judge explains that the numbers shown in the system are not always updated and should not be confused with the most accurate or final figures. Despite this explanation, there is some resistance, as the individual insists on what they believe the correct numbers to be. The judge then confirms that a new payment structure has been set, requiring $345 plus an additional $69 starting from April 1st. This clarification is important to establish a clear and enforceable plan for child support payments. The court ensures that the amount is properly documented so that it becomes a legal debt. This means the obligation will not disappear over time. The focus of the court is to make sure the payment system is accurate and enforceable. The judge continues to emphasize the importance of listening and following the legal process. Overall, the court is setting a firm structure for accountability.
Yeah, I'll
And
go ahead
then
and
let
reach
me
out to
know.
her.
Because if I do need to file something, I can, if she can fit into the program, so that we can get consistent payments in. Okay, Mr. Tillis, I think you've heard Judge Manning talk about the PAC program a little bit, and what that's called is parent accountability. And what's different about that from fatherhood is that it's governed by the court. She still has to report to another judge, Judge Brasher, who meets with them once a month, and then Ms. Freeman, who is on the call with us today, will monitor her. She has weekly contact with the participants of PAC to make sure that they're on the right track to do. And if there are any other barriers, she can help provide services from the state. Not that this is the case with the current CP, but say, for instance, if a criminal record is preventing them from being able to get a job, the state will provide what's called a bond to assure the company that there will be no problems, and then that person can go work. So if there's a job out there, Ms. Freeman will find it for her.
There she
Okay.
is.
Okay.
There she
Will I
is.
get will I get a copy of this?
Oh, she's back.
Oh, okay.
Order? Yes. Okay, I believe, well, okay. Well, we're done. So Ms. Pate, what's happened is this was an adjudication of arrears. This is the last case on the calendar. And so the court proceeded to go forward because we need to let Mr. Tillis go back to work. The arrears were adjudicated at $4,292.59 as of February 28th. Your current child support payment is $345, and a repay of $69 has been added to begin on April the 1st.
When I looked into the system, the child support balance is only supposed to be $2,900. When I looked into the system, the child support balance is only supposed to be $2,932.59. That's the amount that's in the system. What's the $4,000?
Because when you looked into the system, we can only start charging for the amount of time until we get to this, which is an adjudication of arrears. Mr. Tillis provided what's called an affidavit, which was in the packet that you received when you were served. And that's the amount that we are adjudicating right now. That has been added to that $2,000 in the system. to bring your total up to
But you're not supposed to add that to the
$4,292.
$2,000. That's included in the $2,000. The reason why I'm saying that is
That's what court is. No, that's what court is for. That is literally
no,
why we are
no,
here
what I'm
today.
saying is,
Hold on, ma'am. Listen to Ms. Clark Davis.
I hear her. No, what I was saying was the
You're not listening to her
$1,000.
because you're talking over her, so I'm muting you. Go ahead, Ms. Clark Davis.
So we can't put on the system the arrears affidavit until the amount that's on the arrears until we've had a hearing. We had a hearing today and we added that information to the system, which is why the total is now combined to the additional amount. The other thing was this case did not have an arrears repay added to it. So that's where the $69 extra a month is coming for to pay down the balance. Now, if you have proof today that you have paid Mr. Tellis that money from the affidavit, we're open to seeing the receipts.
Okay, but this is what I'm saying. When we received the complaint for child support, when it says that we owe the $1,360, then that's as of 7/7/2022. The only thing that's added to the $1,360 after that is the $354 that's supposed to be paid monthly. Mr. Tullis has received monies through IWO, and he's also received monies through direct payment. So another arrears affidavit needs to be completed by Mr. Tullis. As of January 31st, Mr. Tullis has received at least a payment of $1,000 on the case. So that arrears balance needs to be done over. This the $4,000 is not correct.
Your Honor, do you need to hear the testimony again with Ms. Pate currently present, or does the court want to rely on the testimony that was given earlier?
I mean, I heard this testimony was given earlier. I'm fine.
So that's what I'm saying.
Your Honor, then
shifts toward what happens if payments are not made on time. The judge explains that if the payments are not made consistently for 60 days, administrative actions such as license suspension may begin. After 90 days, the case can be referred for further legal review, including contempt proceedings. If the court finds that the person has the ability to pay but chooses not to, there could be serious consequences. These consequences may include a court-ordered payment plan called a purge. If the purge is not paid, there is a possibility of incarceration, although this is within civil law, not criminal law. The judge clarifies that the purpose is not punishment, but enforcement of responsibility. The court also mentions support services that can help individuals find jobs or overcome barriers like education or past records. Programs like the Parent Accountability Program are introduced to help ensure consistent payments and provide supervision. These programs include regular check-ins and assistance from state services. The goal is to support both the parent and the child by improving financial stability and accountability.
So if the system says that I only owe $2,930 something as of January 31st, then we don't add the $1,360 to the $2,900. The $1,300 is as of July 2022. The $2,900 is as of February 2023. If we do 3 times 12, that's like what?
She's frozen, and I'm absolutely happy with I mean, she hasn't presented anything other than what she thinks that the math is done wrong.
thank you, Your Honor. Then we'd ask that that be the final order of the court. Mr. Tillis, am I frozen too?
Yes, ma'am.
Oh, okay.
Yes, ma'am.
All right, Mr. Tillis, then everything stands as we discussed just a moment ago. Ms. Freeman, I still need you to reach out to Ms. Pate when you have a moment to see if she needs any additional services.
Will you guys send me this information today?
Yes, sir. Well,
okay.
as soon as the court signs the order, you'll receive a copy in the mail.
Okay.
Oh, if you put
All right.
your email address in the copy the email address out of the chat, which is court120@dhs.ga.gov. Send a message to that email on Friday or after Friday, and we'll send you a copy of the order.
Can you? I don't have it in my chat. Can you say it to me one more time so I can write it down?
Yes, it's court, COURT 120 at dhs.ga.gov.
At DHS,
Dot
which is
GA
GA
dot GOV.
.gov. And you said I need to send an email to you guys, or you?
Yes, if you will send an email to us so that we have your email address, we'll send you a
Okay.
copy of the order.
Okay, so
Thank you.
all right, so I just went on the system now, and the arrears balance is only $3,277.59.
System is not an updated number.
Do you
The
guys still need
updated
me
number
now?
is $3,277.59.
Number on the system is not an updated number.
Do you guys
Mr.
still
Tillis,
need me?
no, sir.
Now, the order has only been in effect since
Thomas.
2021. It's only 2023.
Thank you, Mr. Tullis. You can go
Your
ahead.
Honor,
This is why I
Mr.
don't like
Tillis.
y'all. Y'all don't care what's
Yeah,
right. And this is what I be talking
Thank you,
about.
sir.
Y'all just what I want to do on my case. I do not owe no $4,000. I only owe $3,277.59, and that needs to be the balance of the owner arrears.
The number that is on.
You don't add $1,000. No, ma'am.
Yes, ma'am.
Arrears.
Yes, ma'am. Yes, ma'am. The number that is on the system.
Legally,
is
you're
not
illegally
an updated
maintaining.
number. The number on the system, once again, is not an updated number. It is behind. Stop unmuting
Number.
because the more you talk over me, I will continue to mute you.
Ma'am,
I'm telling you that the number that shows up on the system is not an updated number, but you refuse to listen to me.
Ma'am, when will I
It
get
is
a
not
copy of
an
the court order?
updated number.
Because I
You
don't have
are not
no
listening. Okay, unmute yourself one more time and I will remove you. That's it.
Discussion focuses on the exact balance owed and how payments have been recorded. There is some disagreement about the total amount, with different figures being mentioned based on system records and court calculations. The judge and court staff explain that the official amount includes all verified arrears and payments after a formal hearing. They also clarify that some payments made in the past must be considered in the updated balance. The importance of providing receipts and proper documentation is emphasized to ensure accuracy. The court confirms that the final order will be sent to the involved party, and instructions are given on how to request a copy through email. Throughout the conversation, the judge repeatedly stresses that the system numbers may not always be up to date and that the court's official ruling is what determines the correct amount. The session ends with a firm reminder to follow proper communication and court procedures. The final outcome is a structured, enforceable child support order designed to ensure ongoing accountability and support for the child.